Good morning friends, Namaskar, Sat Sri Akal and Adab. This is my 238th video and it continues with the pleading factors on resumption notices. The topic here stands the same: surplus lands. Now this is a very important pleading. I have mentioned in some of my videos earlier, but I will rebrush the same. Why this becomes important? I pleaded and I have been pleading in my cases that plaintiff would like to bring on record the discrimination faced by the law-abiding citizens within the cantonments of India. As an independent nation with the constitution which gives us the right of equality, that even if, as per so many reports made, there shall be no land declared surplus within the cantonments. This is what the ministry has been doing in the past. They pass out executive letters and we guys are discriminately hammered. This is a clear misuse of constitutional rights of citizens. Read the Annexure, page 694, Cantonment Law, chapter 22. Read section 4 for the same. If the department has to make laws in its own hands, then cantonment limits or boundary pillars should be defined unconstitutional, where the Constitution of India is not applicable. As simple. Let us be barred. Let us remain slaves what we were pre-1947. The Constitution of India and rule of land does not prevail within the cantonment boundary pillars. If you read Government of India, Ministry of Defence, U number letter 2453 dated Director General Lands oblique 83 dated 8th April 8, 1983, circulated by the ministry then, were further under a DG letter number 5 oblique R&D oblique DLC oblique miscellaneous 83, even letter dated 6th August 1983, that there shall be no land declared surplus within the cantonments. Guys, what is this called? Is it unconstitutional or is it constitutional? Whether the rule of the law remains. How can a ministry assume to make such executive orders instead in parliament at different stages from 1969 to 1992? Land policies or KLP calculations has been advised to be adhered before issuing a resumption notice to any OGB or a leasehold bungalow. Land audit reports are not being made. Well, I have a land audit report of 1992 for Ambala Cantonment, which I'll be discussing in my further videos. Surplus lands are not being declared. No KLP calculation is happening. That is why that 2003 letter and 1995 Quartermaster Journal. So this is where I am trying to rebrush and culminate. Please understand, follow these videos in a chain link kind of a story. So now for Haryana and Punjab, Himachal Pradesh, these letters become very important. Nothing more could have been proven that the Director General Lands, either army authorities, don't want any more bungalows or lands within cantonments, as there is already surplus lands as per these land audit reports which I just mentioned. The clause of surplus land as per policy is very clearly stated in the resumption policy, page 838 of Cantonment Laws, chapter 25, where the KLP calculation is also written. You read Cantonment Laws 2006, chapter 6, land audit on page 338. Where are these land audit reports for your and my cantonments? The land audit report for Ambala was made by Government of India, Ministry of Defence, letter number 9 oblique LA oblique RSA additional DG DE 5928 Director General Lands dated 8th December 1992. We must read the para 2 of the same letter. It clearly goes down to say that Ambala has a surplus land of 418.04 acres. Further, I just read in my earlier video the Paschim Mukhyalaya letter issued on 18th April 1995, which clearly said that the KLP has to be calculated. The KLP which was calculated as per the 1971 order is to be abolished and the 2001 is to be done. I have already discussed the KLP in a video. Jumble them up. My friend from Jhansi, please, you will become a better consultant. Watch these videos and learn. I refuse to say that you cannot be a good consultant. You can be one of the best consultants, but please educate yourself. So proceedings had to be halted, but are they being done? No. This report of Director General Lands Audit very clearly says that 7th August 2009, it says in report number 6 of 2003, Defence Services para 26-4.3, land audit made 418 acres surplus in Ambala. Further surplus land issues within the cantonments under Western Command, Union of India formulated a committee. This committee was made by Additional Secretary of Ministry of Defence, Mr. Somi Tandon, which I just mentioned in my earlier video. It says all these resumption notices should be halted. Dairy farms should be used. So what does the whole story rebound back on our pleading? We can plead under Article 300-A, the right to property is a constitutional right of every citizen, and no person can be deprived of his property except in accordance with the law. It is submitted that the actions of the defendants, here it means the Ministry of Defence, it totally contrary to the provisions of the law and the violative of the Article 300A. Because the plaintiff, that is the bungalow owner, sought to place on record some judgments of the trial court, similar resumption notices in Ambala cantonment. I have been always talking of 7 resumption notices issued during the period when my bungalow was issued a resumption notice from 1970 to 75-76. 10 were issued, 3 were taken to the culmination, 7 bungalows were left. Why? So we are pleading naturals, and similarly this must be in your cantonment. Dig into your cantonment records. How many bungalows in the last 40, 70 years, 60 years have been issued resumption notices and pendencies? How many have been resumed and how many bungalows have been put to use? Make a list. All this is going to be your benefit, not mine. I am just trying to educate. So resumption notices which are pending in your cantonment, dig those records, file an RTI. Like in Jhansi, we have this bungalow who's a consultant, his resumption notice is pending. 7 in Ambala, maybe 1 or 2 in Jalandhar. So we need to dig in, all this. This will be very important for us because this will become a pleading of natural violation of principles of natural justice in the courts. So now in the last we can plead that Article 14 of the Constitution, which gives us the right of equality, has been openly discriminated, and arbitrarily the Ministry of Defence or the local DOs tend to take law in their hand. In isolation, we bungalow owners are heckled. Friends, please wake up. Please, for God's sake. We guys were never converted into new grants because we were revenue free grants, and that is why our GLR honestly till date speaks of old grant. Why doesn't that GLR say a grant under GGO so and so? Why does it need to say a grant? Because the GLR was made first in 1925, and by that time the Grant Act was already there, or the Crown Act 1895. So they could have very submissively written grant under GGO so and so. Why admission deeds in the remark columns are mentioned? Please understand. Good day. Thank you.